Welcome back to the Legislative Council inquiry into Drug, Poison, Controlled Substance Amendment Bill 2023. Welcome to member of the public watching via live broadcast. Joining us with this session is we've got the Victorian Alcohol and Drug Association. Joining us with Dr. James Petty and Mr. Dave Taylor. Just before we continue, quickly I'll read the information to you gentlemen. Regarding information you provided today, all evidence taken is protected by parliamentary privilege as provided by the Constitution Act 1975 and further subject to the division of the Legislative Council with standing orders. Therefore, the information provided during this hearing is protected by law. You are protected against any action for what you say during this hearing, but if you go elsewhere and repeat the same thing, those comments may not be protected by this privilege. Any deliberately false evidence or misleading of the committee may be considered contempt of Parliament. All evidence is being recorded. You'll be provided an approved version of the transcript following the hearing. The transcript will ultimately be made public and posted on the committee website. Just for recording purpose, could you please state your full name and the organisation you're representing, please, gentlemen?
Yeah, my name's James Petty. I'm from the Victorian Alcohol and Drug Association.
Dave Taylor, also from the Victorian Alcohol and Drug Association.
I understand you've already made a submission, but I'll open the floor for your quick opening statement before let the committee ask any questions.
Sure, thank you. So good morning and thank you for the opportunity to speak today. I'd like to begin by acknowledging the traditional owners of the land on which we meet, the Wurundjeri people of the Kulin Nation, and pay my respects to their elders past and present. I also recognise their ongoing connection to land, sky, waters and culture. Sovereignty of this land was never ceded. It always was and always will be Aboriginal land. I'd also like to acknowledge the expertise and lived experience of people who use alcohol and other drugs, those who have experienced AOD-related harms, and those who have engaged with the treatment system. Their perspectives are invaluable, and VAADA appreciates their contributions. VAADA is a member-based peak body and health promotion charity representing organisations and individuals involved in prevention, treatment, rehabilitation, harm reduction, or research related to alcohol and other drugs. VAADA welcomes this inquiry and supports legislative reform in the area of cannabis. While we broadly support the measures outlined in the bill, we have a couple of recommendations for minor amendments to strengthen its efficacy. Cannabis is the most commonly used illicit substance in Australia. Nearly half, 41% of Australians over the age of 14 have used cannabis in their lifetime. And surveys consistently show that cannabis is easy or very easy to obtain, and its price has also remained largely stable for more than 3 decades. It is clear that criminalisation has failed to suppress its use or availability. Since the legalisation of medicinal cannabis in 2016 in Victoria, alongside shifts in the illicit market, cannabis has effectively become a de facto legal substance for many Australians and many Victorians. A person like myself, white, middle class, educated, can message a dealer and have cannabis home delivered in a matter of hours. I can choose the strength, the strain and the form it comes in. Or I can visit my GP for a prescription, or even easier, use a dedicated cannabis telehealth service, have a 5-minute chat with a nurse and walk away with a script. My options range from dry herb to smoke or vape, oils, capsules, sprays, creams, lozenges and others. However, this de facto legal status is not universal. If you are homeless, Aboriginal, from a culturally or linguistically diverse background, a young person struggling with mental health or in contact with the criminal justice system, the risk of arrest for cannabis possession is very real. This is a serious injustice. For some, cannabis is functionally legal, while for others it remains a gateway to criminalisation and the significant hardships and disadvantages contact with the criminal justice system entails. While there are diversion programs, these are limited and underutilised. In 2020-2021 financial year, Victoria recorded nearly 12,000 cannabis-related arrests, with 95% of these for personal possession as opposed to trafficking. There are harms associated with cannabis use, particularly for young people. But criminalisation is neither an effective nor proportionate response to these harms. The social costs of cannabis in Australia have been estimated at $4.5 billion annually, with more than half of that attributed to criminal justice costs. Yet prohibition has not reduced demand, supply or harm. Criminalisation has strengthened the business model of organised crime groups and ensured that their business model remains profitable. This bill represents a modest but important step towards a more rational and evidence-based approach to cannabis regulation in Victoria. The risks that this bill, if passed, would increase harm is minimal. The ACT, which introduced similar legislation in 2020, has not seen an increase in cannabis use or related harms. In fact, cannabis-related arrests have reduced, as you would expect. Cannabis-related ambulance attendances and ED presentations have remained stable. Furthermore, a recent study, the Lambert study you all mentioned before, of over 300 samples of cannabis cultivated at home under the ACT laws found it was on average milder than illicit cannabis, with an average THC concentration of 9%, where 30% would be considered very high-strength cannabis. In summary, VAADA strongly encourages the committee to support this bill. It is based on best practice both locally and internationally and is a necessary step towards a more equitable and effective drug policy. We have suggested minor amendments clarifying the rights of tenants, ensuring people under the age of 18 do not continue to face criminal charges for possession, provision for evaluation of the laws of the bill if passed, and a well-funded education campaign informing Victorians on the changes. Thank you, and I welcome any questions from the committee.
Thank you, Dr. Petty. Mr. Taylor, any?
No, I'm happy with...
Okay. Thank you for your opening statement. I'll quickly have a question, then I'll open up to the rest of the committee. There's two questions. I'll just reflect in your submission. The lesson one is your recommendation in this your recommendation submission that you include requirement of government to evaluate decriminalisation, including the potential of expanding decriminalisation to other cohort of illicit substances. Could you just make some comment or expand on that, unless we meant to by other cohort of illicit substance?
Yeah, absolutely. So, in the ACT, they decriminalised cannabis in 2020, I believe, and then following that, decriminalised possession of other illicit substances. Criminalisation is not just bad policy in relation to cannabis, it's bad policy in relation to most illicit substances. And so, I think VAADA really sees this, the bill, as a sensible first step in much needed drug policy reform. And VAADA has always supported, or for 50 years has supported, evidence-based drug policy, and we would see decriminalisation and or legalisation of small amounts of possession of small amounts of illicit substances as evidence-based.
Okay, thank you. Just another thing I've listened to your submission, which I want to refer to. Just the paragraph under relation to the problem with criminalisation. You paint a very picture relation to First Nation people and other migrants, refugees people, cohort disabilities, experienced poverty, mental health issues, substance dependence, and homeless. Unsurprisingly, they are pretty much subject to the hard end of the law. It's painted from that submission to paint a very racist or discriminating picture of relation to Australia. It is something not foreseen or from people who try to come to this country. Would you try to paint this picture? I just want you to have some comment to that.
Yeah, sure. Drug criminalisation has its origins in racism. Opioids, heroin was first criminalised in Victoria in 1901, in part as sort of part of the White Australia policy, and to clamp down on Chinese-run opium dens and to promote Anglo-run, or to promote and protect the business model of Anglo-run pubs. Drug criminalisation, started with racism, and I'm not saying that's the intention of politicians today or the intention of police today, but it's got its origins there, and we still see a flow-on effect of that.
And we do see certain cohorts overrepresented in policing statistics, and they're less insulated through disadvantage. So whether that is, whether that's just inadvertent or otherwise, it is a stark reality.
Thank you. Mr. Ryan?
Thanks, Chair. Thank you both for coming in. You mentioned in your opening that you can get cannabis on demand through the black market. You can get a prescription. To what extent do you think the provisions of this bill, if passed, would affect that?
Would it reduce? Are you asking if it would reduce demand?
I'm asking how you think it would affect it.
Or reduce the, it certainly won't reduce demand, nor will it reduce the accessibility. If this bill is passed, someone like me could still message a dealer and access cannabis very easily through the illicit market. I don't think the model presented in the bill, I don't think its purpose is to entirely supplant the black market. And I certainly don't think it will have that effect. It's a pretty modern, the black market for drugs is long-standing, robust, very complex, very powerful. This bill is a very modest step and won't be able to entirely supplant that. We certainly might see some people who currently access cannabis very easily through the black market cease to access it through the black market because they'll start cultivating it themselves or have a relationship with someone who gifts it to them. So those would be the only effects I anticipate, but it wouldn't be, the effects on the current mechanism of access or current demand for black market cannabis or medicinal cannabis. I don't see it having a huge effect.
Obviously, given your remit with respect to alcohol and other drugs, I'm wondering if you've got any reflections on the current state of the alcohol market and or the tobacco market and what you think we might need to do in thinking about the creation of a cannabis market, lessons we can learn from current issues associated with either or both of those.
Yeah, it's an interesting question and we could really talk about it all day, I think. There are definitely lessons to be had, I think some warnings from the alcohol industry and the history of the tobacco industry. I think the tobacco industry is really interesting because, in the 60s and 70s and 80s, they were promoting false evidence and suppressing good evidence about the harmful effects of smoking, and it took us a really long time to accept it. And for it to become widespread public knowledge that...
So I argue they're still doing it.
Yeah, absolutely. But, Australia took a really, really strong, has taken a really, really strong stance against that influence. And as you know, Australia has some world-leading tobacco laws. We're arguably seeing a backlash against that or an undercutting of that with the rise of vaping and the crime associated with that, particularly in Victoria. So I think there are interesting warnings or interesting lessons to be learned there. I think lessons from under-regulating the industry, potentially lessons against over-regulating the industry if we established a for-profit cannabis industry in Australia or in Victoria. For alcohol, I think the lessons primarily are about warding off against regulatory capture. Alcohol is, in some ways, well regulated. It is taxed, not very well, not very effectively. It is restricted to over 18s. It is the supply is well controlled. No one drinks methanol in Australia. No one gets poisoned by methanol in Australia. So on one hand, alcohol is a relatively safe substance through regulation. On the other hand, we do see, alcohol advertised widely. We don't see enough controls around outlet density. We see the alcohol industry shape or influence policy. So, for example, a few years ago, there was an inquiry into the home delivery of alcohol. The Victorian government heard very detailed information about the association of rapid delivery of alcohol with suicide, with domestic and family violence, with a range of harms. And then the Victorian government proceeded to expand the hours and the licences for rapid home delivery of alcohol. So I would view that as a form of regulatory capture, and I think that would be a warning against establishing a for-profit cannabis industry that then would see those for-profit interests seek to shape policy.
Thanks very much. Thanks, Jeff.
Thank you, Ron. Ms. Payne?
Thank you, Chair, and thank you to you both for your contribution in the submission and for presenting for us today. I want to talk about in your submission you talk about expungement and the recommendation there of expungement of prior criminal convictions for personal possession and use of cannabis. Can having a criminal record impact a person's access to AOD services and treatment? And I'd like for you to expand on your thoughts around expungement as well.
It's an interesting question. Officially, no, having a criminal record shouldn't impact a person's access to AOD treatment. But as we know, having a criminal record can be associated with other difficulties in housing, in employment, in a range of other areas and accessing other services. And so while the relationship or the relationship between having a criminal record and access to AOD services might not be direct in terms of people being turned away as soon as, come into our AOD treatment service, oh, you have a criminal record, get out. I don't think we're seeing that. But in terms of the hardship people with criminal records face, that can make accessing AOD treatment more difficult. There is something else to say about the forensic system, which is, I suppose, what we refer to. We refer to a portion of the AOD treatment system that is kind of reserved for or specialised for people in contact with the criminal justice system. And it's a really important part of the system. However, there are challenges with it. It is underfunded, and we do see differential and inconsistent access to AOD treatment for people in contact with the criminal justice system. I'm not sure if that sufficiently answers your question. Dave, do you have anything to say?
No, I think you've covered it pretty well. Yeah.
And would you say that sort of criminalisation precludes someone from accessing or having greater access to health provisions?
Yeah, in terms of the challenges they face, we know people that face the kinds of challenges that people with criminal record face often are underserved in terms of health and welfare services, often get inconsistent access to those services and don't necessarily get the service they need. So, someone with a criminal record, but also who's experiencing other challenges might turn up to say, homelessness and active AOD use or active AOD dependence. They might turn up to a treatment system and be turned away because of their challenges, because of their complexity. Or what might happen is that they'll turn up and say, I need to enter withdrawal and then a rehabilitation centre. And what that service has to offer is case management and daily check-ins, which is really insufficient for the needs of that person that I kind of painted.
The other side of this is that if people have been criminalised for their drug use, and then that generates a level of stigma and self-stigma, and so that will quite possibly contribute to people not wanting to engage in service because they're not wanting to talk about something which they're feeling stigmatised about. And so we can find that the criminalisation of drug use can exacerbate stigma, which will reduce the likelihood of people engaging in help-seeking behaviour, which might mean in some cases that people, because they're not wanting to get help, some of the challenges they're facing will progress and become worse, and then it may well end up that they're needing to engage in emergency services, or they're compelled to go in through the justice system at greater harm to themselves and greater burden to the state.
Michael?
Thank you, Chair. Thank you. Good morning, both. I'd also like to talk about the expungement of past and historic convictions for cannabis possession and use. You touched on your answer to Mr. Batchelor that there would still be a black market, and if I'm quoting correctly from the National Drug Strategy Household Survey in 22-23, we know that in the ACT, around 12.4% of cannabis users grew their own plants under the model, which, though considerably higher than the national average, is still quite a small number. How would you determine what convictions would and would not be vacated? Because I guess the question is, how do you know that under an alternate reality they would have been growing their own cannabis and complying with the law, or whether they would have still been utilising the black market, as many in the ACT are still doing now?
I wouldn't equate the idea of expungement of previous convictions with the notion that these people would have been growing their own cannabis. What I would say is that the criminalisation of cannabis, of minor possession of cannabis, has produced injustices, and that the expungement would be a means of redressing that. So I wouldn't be seeking to expunge convictions for the 12.4% of people who would have grown cannabis if they'd had the option. I would be quite comfortable with extending that expungement to all people who have been charged with the minor possession of cannabis.
So even for people who, even if they were to then, maybe to use the wrong word, but to re-offend to purchase off the black market,
Yeah.
which would still remain an offence under this proposal, even though they would still be committing a criminal offence under these new laws, you would be expunging them for previous.
They wouldn't have had the opportunity to grow plants lawfully in the old laws, so yeah, we would be taking that approach.
Yeah, thank you.
We'd make the presumption that they either would have grown their own plants lawfully or they would have been gifted.
Yeah.
Given those circumstances
We
didn't
can
exist
never really
previously.
know. That would be the assumption that you would make. Yeah.
But, VAADA would support the expungement of those convictions regardless of whether those people continue to purchase.
Thank you. Yeah.
illicit.
The evidence we've heard, and I think you've touched on as well, is that in the ACT, for example, there wasn't an increase in emergency healthcare demand, but there obviously is a very important role that services such as yours play, in particular at that early intervention point. And anecdotally, we've heard that there has been some increased demand for services such as yours, and I'll probably say that's a good thing for that early intervention approach. Under this model in Victoria, what resources would your sector need in order to successfully provide those supports to people under decriminalisation? And I guess in monetary terms as well, if you can define it.
Yeah, look, I'm probably not going to be able to come up with an exact dollar figure, but I would say that our services, just to clarify, VAADA doesn't actually provide any services, so we're a peak body member
You're the
organisation,
member,
but
sorry,
we represent organisations that do provide services.
Yeah.
The AOD sector in Victoria has been historically underfunded for since inception, basically. So they would definitely need additional funding. And what we saw in the ACT was, which obviously is a very, very small territory, we did see AOD services receive sort of dedicated and increased funding to respond to that increased demand, because people, as Dave was saying, if stigma is removed from the possession or use of a substance, people can often feel much more confident and comfortable in presenting to a service. Dave, are you able to give a dollar figure?
I'm not, but I think I'd probably put it to the committee that, the wait list data for alcohol and drug treatment, the daily wait list data has increased from around 2,400 from the start of the pandemic to over 4,600 last year. And I can provide the exact figures and the times when those surveys were taken on notice if that's desired. So, as James intimated, there is a significant lack of capacity to meet current demand. There is recent and strong research indicating nationally that there's a significant portion of Australians who would benefit from clinical treatment who are missing out. And so there's already those demand pressures.
Yeah.
Yeah.
I realise I'm over time. I'm very sorry. If I can quickly ask, in a rough term, of a percentage increase of demand that you would expect to see under this model? Can you perhaps take that on notice as well? I realise I'm putting you on the spot.
We can
there.
take it on notice, but I think that it might be difficult to provide a clear figure. So we can take that on notice and provide you with a response of some sort, but I can't guarantee we'll be able to just give you a number.
I appreciate that. Thank you.
I'd love it if that level of evidence and research was out there.
It'd be great if we had it, but even if you can give us a broad indication, that would be very helpful.
Just for context, a lack of a sort of robust and efficacious data system is something that's plagued the Victorian AOD sector for a long time. So we simply don't have that data. People often also present to treatment. Maybe the reason they're presenting to treatment is the use of alcohol, maybe the use of methamphetamine. they're also using cannabis, and that might be not the first priority for treatment, but one of the other priorities for treatment.
Yeah.
And then also just in relation to youth services, they're probably, cannabis would be higher on their list than the average, or higher on their priorities than the average AOD treatment service. It is a complex picture.
Thank you.
And we only count those people who present to treatment. So the figures I offered before is very much a conservative estimate of demand. It's not, it would be much higher if we were to capture people who aren't engaging and perhaps because of stigma or any other reason aren't engaging in treatment but may well benefit.
Thank you. Thank you, Chair.
Welcome. David?
Thank you, Chair, and thank you for your very thoughtful contribution. An issue that's been bandied around a bit is the question of how the bill should best treat under 18s. I wonder if you'd like to share with the committee your thoughts on that issue and also the adequacy or inadequacy of the bill in that regard.
In terms of that, VAADA, as we say in the submission, we support provisions that reduce the access of young people to cannabis. Sorry, I'm not sure if that made sense, but that limits. We want to limit the access that young people have to cannabis. We don't want to see that access increased. We don't want to see that access deregulated or proliferated, because there are some health concerns, in particular mental health concerns, for young people if they're using cannabis early, if they're using cannabis very intensely. But what we don't want to see is the continued criminalisation or increased criminalisation of young people for possessing cannabis. So, for example, under the proposed bill, if a 17-year-old was caught with instructions about how to cultivate cannabis, they could be arrested and charged for that. And by instructions, I mean a text message or a YouTube video on their phone telling them how to cultivate cannabis. So I'm not saying that's necessarily likely, but I don't think we necessarily, if it's not likely, we don't need it it's not needed within the law. And I don't see any benefit coming out from that of a 17-year-old ending up in being arrested and charged for possessing a text message or a YouTube video. In terms of the bill's adequacy, I think some people have talked, and certainly some of the other submissions we've read have talked about security and storage provisions. So maybe requiring people to store, maybe people who are going to grow cannabis under the bill, requiring them to store it in a way that reduces or minimises access of youth to that cannabis. VAADA would support that. It would be very difficult to police, very difficult to enforce, and I'm not quite sure about how to get around that. But I do think there could be, good requirements for ensuring that there isn't access to cannabis in public space. So, if someone's house backs onto a walkway, a creek, whatever, public land, having your cannabis plants grow right over that fence, and I think is a bad idea. So I think there can be provisions around limiting access to the public to the grown cannabis, the cultivated cannabis, and young people as well.
There's a couple of things I'll put to you on top of that, and I certainly appreciate James's comments. We don't have any rules and regulations. If I was a smoker, I happen to enjoy having alcohol. I don't need to keep those things under lock and key, even though I've got young children. So we probably need to consider that. We are very supportive of measures that ensure that young people don't engage unnecessarily with the criminal justice system. We've already got a very much an overburdened system. So where we can look at health-led responses or diversion, or importantly early intervention programs, that's really important. And one of the things we talk about is developing an education campaign in this submission. And we'd want to make sure that such a campaign wasn't, for instance, developed by the police. And we've seen a couple of examples where that missed the mark, being generous. And where it will be something which is peer-led, so led by people who use drugs, by people from community who can really strongly relate and build a strong rapport with young people who may be seen as at risk. And so we'd be very supportive of those sorts of measures. But certainly the example James offered at the start, that would be an unfortunate outcome if that 17-year-old was drawn into a criminal justice response for having watched something on YouTube.
And I will just say, the idea of you can't control for everything. So young people will continue to have contact to or have access to cannabis, regardless of whether this bill passes or not. And really, what the goal should be around the government's goal, and certainly our goal, and the AOD sector's goal, is providing young people the support and resources that they need to, regardless of whether they are exposed or have access to cannabis, to still lead a healthy and happy life. And it brings to mind an evaluation of a prevention program that I read that was run in Footscray in Maribyrnong area, probably 10 years ago now, and it was an AOD prevention and early intervention program for young migrant and cold background youth. It didn't mention AOD at all. All it was an after-school soccer program where you didn't participate if you were drunk or high. After the soccer program, they had local parents cooking dinner, and that was it. And it was very effective. It's hard to measure exactly what you're preventing, but it was very effective, had very high engagement, and unfortunately it was just a trial and then it was defunded. But by providing those kinds of resources, that's going to be much more effective than a provision in a bill that says that defines how or where or what should be done to prevent access to cannabis by young people. Supports are much more important.
And I think just the comments, which I know we're bouncing off each other here, but I think it needs to be premised, this bill, that what we've got now is deeply unsatisfactory. And so, we're really looking at trying to enact policy that makes it a little bit less bad. We're not going to be able to eliminate drug use. That's simply a reality. And so we need to take that off the table. And so there's always going to be risks. And young people already, as James indicated at the start, that indicated that drugs are easy or very easy to obtain. And so we need to keep that in mind when we start questioning any risks associated with this bill, that those risks are already clearly evident and that young people are, it's very easy for young people to already procure these substances.
Thank you.
Spiali?
Thank you, Chair. And Dave, I'm going to follow straight on with what you were just talking about. As you've described it, the current laws we have are unsatisfactory. We often talk with conversations about legislation like this about risks associated with changing the laws. Can you tell me a bit more about what are the risks and the harms associated with not changing the laws we have now?
We've already mentioned the 2.4 billion criminal justice burden on the state associated with what is predominantly prosecutions and policing activity toward people for consuming cannabis. So there's a significant impact there, the significant impact of having a criminal record, the significant impact and the related service deterrence, deterring people from engaging in service due to stigma, to simply name a few. James, do you have anything to add?
Yeah, we'll just continue the status quo. I think, the current laws we have are insufficient, as is the status of the AOD treatment system, or the funding of the AOD treatment system and its adequacy and its ability to meet demand. And if we don't, none of these problems are easily solvable. We need sort of multi-pronged approaches. So, this bill is not going to solve everything, but I think it's a step in the right direction. And that there are really considerable risks of not doing anything. We'll just continue with the same insufficient set of systems that fail a lot of people ad nauseum.
And the state has, at this point in time, we've always got scarce resources. And I think it was 11,000 arrests for cannabis possession.
Close to 12.
There's a huge policing resource there, and I think that we'd all welcome police being able to reprioritise some of their work and redirect it toward more serious crime. I'm not sure that that is the best allocation of police resources, especially if we read the papers on any given day. And so, yeah, I think the status quo is clearly unacceptable at a system, cost, health and stigma level across the community. And it's been that way for decades.
Thank you. Often in these debates, we'll hear views put that if we follow this pathway of decriminalisation, that the sky will fall in, that it's going to be devastating to communities, etc. Are you able to point to potentially some case studies from other jurisdictions, even other parts of the world, where they have followed this reform pathway and what benefits that pathway has had for those communities?
Yeah, I mean, in South Australia, cannabis has had a level of decriminalisation since 1987. In the ACT, it's been since 1989. So that's, nigh on 40 years of some level of decriminalisation. Northern Territory since 1996, I believe. And, those, to use your words, the sky hasn't fallen in those places. And again, what the bill proposes is fairly modest. It's not a radical restructuring of, our entire legal system or polity or anything. It's just it's a tweak really that we'd support. The obvious international example is Portugal. Portugal decriminalised minor possession of more than just cannabis, heroin and other sort of quote unquote harder drugs in 2001, and it was kind of described as a miracle because of the kind of social health and economic benefits from that policy. So I'd really just emphasise that what's proposed here is not going to flip the entire world upside down.
And for Portugal, as the example, what is the before and after look like for that kind of reform?
The before is extensive heroin slums. So there were just sort of shanty towns full of heroin users. They had a really serious drug problem, really serious poverty problem. They still have really serious poverty problems. But the HIV, the spread of HIV was very, very extensive. And look, I don't have data to support this, but the anecdotal evidence is that people in Portugal, heroin users in Portugal, were committing crimes on purpose to be put into prison because they would get a hot meal, somewhere to sleep, and they could buy better quality heroin in prison than out on the streets. Decriminalisation, which it wasn't just decriminalisation, it was part of a suite of responses, saw that really turn around, saw people not arrested for possessing minor amounts of heroin, saw them connected with health and welfare services, saw those, and gradually, not overnight, but saw those heroin slums, for want of a better word, reduce and eventually disappear. And they've got a really strong health-led response now, yeah.
Thank you.
No worries.
Mr. McCracken, would you like to?
Yeah, thank you very much. And it's been a very interesting conversation. Thanks, James and Dave, for the contribution so far. I'm interested to pick up from where Trung started asking questions about the decriminalisation process. I think that you said the bill should have aspects where we should have a process to evaluate decriminalisation and also explore extending that to other substances. What other substances do you think should be worthy of that exploration?
I would say probably, the common illicit substances that people are often or regularly arrested for possessing. And I'd like to underline that we said explore, as opposed to...
Can you? I don't know all the different names of the substances. Can you? I'm one of those people that has never done cannabis before, so I'm probably an outlier there. But
yeah, absolutely.
What are the names of the substances that you think are worthy of exploration?
Yeah, so
emphasis on exploration.
Yeah, absolutely. So emphasis on exploration. Minor possession of MDMA, minor possession of amphetamines, minor possession of heroin or other opioids. Things like that, we would certainly encourage the government to explore decriminalisation of. I think there are certainly some substances that you don't want to decriminalise, or that you want to maintain fairly high controls on. Not that I want to see people in possession of minor amounts of those substances arrested necessarily, but there are substances, say for example fentanyl, carfentanil, nitazenes, that you don't want to be criminalising people. Low level possession of it, as in someone's bought what they thought was heroin or MDMA, and it contains some nitazenes in it. But yeah, you don't necessarily want to decriminalise. There are some substances that you don't want to loosen regulatory control over, I suppose.
I think it's really important to premise this under the notion that general deterrence, which is one of the aspects of the Sentencing Act, offences relating to possession and use of small amounts of drugs, I'm not sure there's a particularly strong evidence base that there's any sort of general deterrence aspect where people sort of feel concerned they're going to get arrested and therefore won't use. I mean, the arrest rates and consumption rates suggest that that's not necessarily that effective. So it's considering this evaluation and considering what worked for one substance, what might work for one substance might work for additional substances. And going to what James said before, again, under the notion of exploring, it would be an unfortunate circumstance if someone felt they couldn't procure heroin and so instead got on the dark web and purchased some nitazenes and fatally overdosed. We can sometimes see perverse outcomes occur from well-intentioned laws which aren't well thought out.
And just one thing I'd like to add is that, earlier in my opening statement I said that, someone like me could message a dealer on an app and pretty quickly obtain some cannabis from the illicit market. That extends to those drugs I mentioned, amphetamines, ketamine, heroin, MDMA. Those are readily available. The IDRS, which Paul and Michael, who you just heard from, run in Victoria, show that access and availability of those drugs as well as cannabis remains very, very high. The majority of people list those as easy or very easy to obtain.
I think my time's up, unfortunately. I could probably ask more questions, but thank you for your response.
Thank you very much.
Thank you, Mr. Cracken. I know Michael's dying for one last question. I know time's up, but Michael, please.
I'll be very quick then, thank you. The ACT model, as you pointed out, from the late 80s, they went to a partial decriminalisation with the simple cannabis offence notice. To what extent do you think that played a role in the results of the 2019 decriminalisation being so positive?
Yeah, I heard you ask this question before, and I would echo Michael and Paul's statement that it is really hard to predict. But I would say that that drug law reform is a process, and that if you start, the more evidence-based drug law reform you have, the easier additional evidence-based drug law reform becomes. So I think that partial decriminalisation with the notice probably did help Canberra, or the ACT, mean Canberra, the ACT was well positioned for those next steps. So I think something like, and we have 2 diversion programs in Victoria. So they're also underutilised, like the SCON was.
Yeah. Yeah. And it was underutilised in ACT.
Yes, only about 25% of people arrested for possession of cannabis access the SCON.
Good to know. Thank you.
Very quick question, Chair.
David?
Do you see any danger in going straight to the proposed legislation as opposed to some sort of gradual process through the old cannabis infringement notice? Is it overly brave to leap to just a full a current Canberra model?
James has indicated that our take on this is that it's a modest reform. I don't really see any reason why we delay this. There are terms like decriminalisation used that carry a level of meaning and depth in the community, but the reality of it is that it is a very modest and small reform, and will probably one of the main benefits will be a reduction in justice interventions in a range of people who otherwise would have nothing to do with the justice system. A useful reallocation of policing resources to target more serious criminal offending. A reduction in stigma, where we're going to see more people probably thinking, I'm more happy to talk to people about my cannabis use and seek help, which is a really good thing. And potentially, an increase in early intervention programs and a focus on these things where people can feel they can get help and it's safe to get help sooner. So I see a number of really positive benefits, and looking across this nation, I don't really see any risks.
Yeah, and sorry, I'd just very quickly add that, Canberra had the simple cannabis notice. Victoria has 2 diversion programs, one with police, one that sits within the courts. I think the proposed bill is the next step. I don't think it's a leap. I don't think it's brave.
Thank you, gentlemen. Our time's up. Thank you so much for coming in with first your submission and contribution today. Very much appreciated. Thank
No
you.
worries. Thank you, Committee.
Thank you for your time. Thank you for inviting me.
Suspend recording, please.
Thank you.